So those are very important things that we're going to talk about this morning. And I'm joined now by Daniel Nkrumah. He is the founder and head tutor of Optimus Optimi special tuition hub. He's a lawyer as well. He's a practicing lawyer at AB and David Africa, and he's going to help us have this conversation this morning. Daniel, good morning.
Good morning. Greetings to your listeners as well.
Yeah, good to have you back again today.
It's a pleasure.
Unfortunately, this guy couldn't join us. And so we'll have the conversation anyway. So let's talk about last week we tried to talk about the will, and I remember one of the things that we spoke extensively about was that if someone dies without a will, then the interstate succession law takes place, isn't it?
Yes.
Certainly. So I want you to break it down. How does a law decide who exactly inherits any of the things that have been left, the estate that has been left?
Okay. Greetings to your listeners once again, and it's a pleasure to serve them this morning as well. So, generally with estates, there are two regimes that we have in the country. I must say, created by law. Two regimes created by statutes, aside the customary aspect of it. If you add the customary aspect of it, then that will become three. But since we became a republic since 1960, coming downwards to the Fourth Republic, we've been governed strongly by statutes. And so the two regimes governing us is the Wales Act and then the PNDC Law 111, which since 1998 we changed all laws that were passed by the military regime from the name laws to become acts. That's why we don't yet go say evidence law or evidence code, criminal code. Now we say criminal acts, criminal offences act, evidence act. So the PNDC law 111 also becomes PNDC law 111 now is an act.
Daniel, I'm asking that why is it called an act and not a law anymore?
Yes, because the Statute Review Commission in 1998 were charged to change all those names so that we don't have sort of a memory of decrees and laws that were passed by the military, because decrees are made by military regimes. And the laws are made by military. So in order to just move away from that, let's just make all those laws have the name Act.
Oh, I see. All right.
Yes, exactly. That's why you call Interstate Succession Act.
Okay.
PNDC Law 111. So as a result, we have the Wales Act and then the Interstate Succession Act govern our estate regime. And if you make a will yourself before you pass away, then you will be governed by the Wales Act. Now, where you don't make a will and you pass away, that is where you will fall, or your estate will fall under the PNDC Law 111.
Okay.
Now, you asked a question about how distribution is done. Act, I must say, in last year or two, Parliament is considering amending the law because of the a problem that comes up with the distribution ratio in the Act. But fundamentally, the Act makes us know that whether you like it or not as a family, the Interstate Succession Act provides that the family, that the direct family of the deceased, should get a premium benefit of the estate of the deceased. So the wife, that is the spouse.
Explain that better, Daniel.
Yeah, so the direct family includes the direct spouse, which is the wife or the husband of the deceased, the children of the deceased. These two get the premium share of the estates of the deceased. Then after they have gotten their share, the rest goes to the...
Sorry, Daniel, not to cut you. I mean, I'm getting it. But what determines that this is premium or not?
No, the premium here, in simple terms, means that all the estates that the deceased left, the when it comes to the distribution, the court is always ensuring that the family gets majority.
Okay.
So they do it in a proportion 3:4, 9:16, and those one. The basic thing is that at all proportion that they do, the direct family, which is the spouse and then the children of the deceased, must get majority of the estate.
Right.
And then the rest goes to the family. This is necessary because before the Interstate Succession Act, we had a regime where the direct family, especially the spouse, where the spouse is a wife or a woman, scarcely gets something from the estate of the husband. Because in those days, we normally see the wife that she has a role of maintaining the supporting the husband, not necessarily that she has a share. So the Interstate Succession Act came to change that position so that it doesn't become that the wife that gets nothing and only gets maintenance from the family when the deceased is gone.
Mm-hmm.
That is why they made it said that at all costs, the spouse and then the children must get majority, and then the rest goes to the extended family, and then the customary successor.
Okay.
Now, this is in line with the interstate, the Wills Act as well, because when you read the Wills Act, even you as an individual, you have the power to decide who gets your estate.
Mm.
But the Wills Act under Section 13 gives us a room where the court would have to look at your will you've created to ensure that at least you've not ignored your spouse and children, especially children and who are minors.
Mm.
So it is in line with that provision. You know, the Wills Act came before the Interstate Succession Act. So once you've created the opportunity where the spouse and the children should substantially get benefits from your estate, it has to follow from there in the Interstate Succession Act. So that is how it works.
I see. Okay, but can you share some real examples where families face some major challenges because no will was in place?
In terms of cases,
Yes,
or you want
if you
practical
can,
examples?
yes, if you have cases, that's fine. But practical examples also do. I mean,
Majorly, for family members not getting any contribution from. I don't want to bombard our listeners with cases, but it's way back from 1950. We have the Corte versus Mate cases where Olenu even clearly made us to know that if you're a wife, you don't practically get any interest in the assets of your husband.
I see.
All that so when your husband pass away, all that you get is just a maintenance, life support. You live in the house of your husband at the interest of the family.
Oh, so if the family thinks you should go, they will sack you.
Yes, provided that, so they all look at goodwill, and then you have a good behavior.
I see. Then
That
if
is
you have
purely how it works.
if you've had an issue with your in-laws, then that is your end.
Perfect. Yes.
I see.
So there were a lot of these issues, and it came down from succession all the way to spousal property when there is dissolution of marriage. All that was how the position of the law was until we started changing that position. We've done significant progress in these two aspects of the law when it has to do with the will and the estate, and then the spousal property rights. But fundamentally, it was because of these problems that led to this Interstate Succession Act being passed to ensure that we compulsorily make it that even though the man did not make a will, crucially the husband, the spouse, which is mostly inspired by the treatment we give to the women, should get some benefits from the properties of the man.
I see. Are there any other examples? I want us to be quite vivid on this so that people can see several instances that has actually happened.
There have been several instances, I must say. So, in 19 getting to the passage of this law, there were situations where the the wife of the husband would contribute significantly, maybe assets, money, or something to the properties that the family even got. They invested in it significantly, but at the end of it, they got nothing, and the family came in to take the properties away. Because at that time the law was that the once you are from a matrimonial family, and you know that the customary succession, it is through matrimonial and patrilineal system. So where you are from the matrilineal system, the wife of the husband does not get anything. It goes to the mother side of the man, and then the patrilineal system also is the vice versa. So if you marry from that in any of those systems, and then you even support your husband in getting the properties, you end up losing anything that you get from it. And as I said, the principle at that time has always been that it depends on your good behavior that you live, that they give you opportunity to live in the house, and your children.
I see.
Not only the wife, you and your children.
Okay, right. So so let's talk about how long does probate usually take?
In terms of making a probate,
yes,
to get your the property.
So, the properties, yes.
If you don't have a fixed.
Hello, David.
Yeah, can I be heard now?
Yeah, Daniel. Sorry. Yeah, I can hear you now.
Yeah. So in the CI-47, which governs how we can apply for probates and all that, doesn't give us a specific duration as to how long a probate can go, because probate can happens in simple terms. It can happen in two ways. One type of probate action is where there is no dispute over the property. So the one holding the LE, which is the administrator of the estate, or the executors of the will, normally will just go to court and then prove it that this is the will of the person, or these are the estate of the person.
Right.
And so it's that one becomes easier, and you can easily get it even within a week. But in the instance where someone in the family believes that property, not only in the family, but maybe you may have a shared interest in that asset, maybe the deceased person have a co-ownership in that asset with someone else, and the deceased person added it to the will. In that case, the person who has a shared interest would come out to challenge it. So if there is a contention as to on those assets of the deceased person, then that can take a while, because definitely the court would have to go through the process of serving notice on the parties involved, and then come to proof to ensure that they clear any form of dispute around the probate and the assets before they now release it for the administrator or the executors to go out and then distribute. So it depends the situation around those assets.
Right.
And even in some instances, the assets that has no, you can have one well or estate where some of the estates has no issues, the others have. So in some instances, the court can make orders to release the ones that does not have any issues, and then the ones that have issues, then deal with it.
Can it take up to 5 years?
Oh, certainly it can. There are a lot of cases in court that have lasted for years.
I see.
They've lasted for years. There have been several instances in that, because it depends. The properties in contention and the dispute between the parties all comes to play. And fundamental, sometimes it even happens in the wills that we even create. Because I said, last week, when you draft a will and you don't actually draft it with clear terms specifying your intentions, sometimes it comes with this problem. And even it goes to the extent that signatures even become elongated disputes in court, because sometimes the children will come and say, this is not the signature of our dad. And so
Right.
now they have to prove that indeed this is and it boils down to the digital world, because now also for we are yet to get a case in Ghana where it will make a ruling on that. That is not that now most companies and most people have electronic signatures that you can easily pick and insert in a document. So the big question now even is that when someone creates a will and inserts the signature of the electronic signature of someone in it, what then happens to that signature? How do you prove that that's the signature of the person? But then, we are yet to get a case on that,
A case on
on
that.
that aspect. But it goes all the way to even signatures becoming a dispute.
Oh, okay. I see. Very, very interesting things we're getting to find out. So it's actually better to put in place some proper planning before you pass, because it can take your family very long to even
Exactly, especially where normally where the properties are where there are wider interests involved in the family. You really need to. That's why last week we said that at least don't wait till you get to 40, 50 before you create a will. Every asset you get, you can start putting it down in your will, and then so by the time you even pass away, at least even if you've not captured every single estate you have, the ones that you've captured can easily be dealt with. Then the other one that you were able to capture will be dealt with by the PNDC or 111. And it comes down to this, the current development also happening, because now I guess you are aware we have digital assets.
Yeah.
Yes, we have digital assets. And the big question, we've not actually seen any development in our laws in this country actually making progress when it has to do with digital assets and then distribution or succession in relation to that. So even if someone has a digital asset, for instance, a mobile money account,
yeah,
or a crypto account,
crypto NFTs
or
and all of that,
those one, or even Facebook, YouTube, the monetization proceeds of those ones. What happens to it? How does it go? We don't even have stronger position of the law, and it's happening in Canada, where Canada is a very developed. It's a developed country, one of the developed countries. A man though made wills, his cryptocurrency account, he didn't create a will on that account. He had an intention of doing that, but he didn't. He forgot to do it before passing away. And at the time of passing away, nobody knew the pass key to that account. And they ended up losing over $190 million.
I see.
Just because the person did not create a will early on that, and the dispute that went around it, they were not able to prove. So it has to be lost. And it is even proving that at least in every year we lose about 20% of digital assets through wills that were not created. So it boils down to the fact that to avoid any dispute around your will or your will and your estate, you always need to ensure that you give your will a clear term of your intentions, so that the court will be able to enforce it very, very well.
I see. So let's talk about business and succession planning. I know what we're speaking about is largely targeted at family and all of that. For business owners listening, why is including a succession plan in your will very crucial?
It is very crucial because in this country, I must say, our business, so we have types of businesses you can set up in this country. You can go through, we have the sole proprietorship business, where it is you directly being responsible and taking all the benefits also that comes with the business. So when there's a liability, you are the one that we come directly against. The assets and you will all be liable. But the other one is the company limited by shares. That one, there is a shield on the owners of the business. So where there are liabilities, it is the company's assets that is used to attach, and not you, the individual that comes in it, unless certain factors are met before we would lift that shield and then come and also charge you, the owner of the business. And so, apart from that, there are other types. And most of the time, our businesses that we create here, in practice, normally are family businesses. The person creates the business having in mind that my family must come and succeed it. So a family member must come and manage it. So it runs through the family. As a result, it becomes necessary for us to create a will. And in some instances, too, like a company limited by shares, the shares of the company is given to members. The ownership of the company is through shares. So we have 2-3 members or more holding shares in the company. So the big question down becomes that where you don't create a will, what happens to that shares? Now, fundamentally, our law, though, have made it possible that in the aspect of company, when you don't create a will, though, imagine that you pass away and you don't create a will, it goes to your beneficiary. The law creates that avenue where, yeah, because when you're getting into ownership of a company like a shares, and then to the extent that you even get putting your money in banks and all these kind of things, you indicate who is your next of kin. And companies also have beneficiaries. So those, if you don't even make a will, it goes to those people. But is it really the person you wanted everything to go to? That is where it boils down to. Or where the company has no arrangement as to who your share should go to. Do you want to allow the law to regulate and determine who it goes to? That is why it becomes necessary that even if you have a shares in the company, you have to clearly make it known as to who inherits that shares should there be any demise that happens.
I see.
And it's one of the reasons
Yeah.
why we don't actually see a lot of SMEs and sole proprietorship businesses succeeding in this country, because the owners die with the company or the business.
Yeah.
There is no succession plan. So especially with the SME, imagine a woman selling kinky and wachi or tomatoes and pepper in a very big store. The person has no idea about making a will. And so if this woman who is being successful in managing this shop pass away right now, what happens to that shop?
Right.
And so that is why it becomes necessary that these people need to also have an idea as to creating someone to be the beneficiaries of their business should there be any situation. Even if you don't want to make it a will, create a beneficiary for that.
You need to create a beneficiary. And how early can you? How early must you do that?
I think with when it comes to sole proprietorship and companies, mostly when you are filling your forms to incorporate the company, those details are very necessary for you to include them from the start. And I say that it's not made compulsory though, but it is necessary that when you are creating the business at the beginning, at least you need to have all these things outlined. And crucial thing too is that sometimes businesses, when you have a business relationship with someone, it can be a partnership or it can be a company. At the beginning of the business, maybe things may not be that blowing. So you may think that you don't need to really create any arrangement like this on the business. But that is where problems comes and companies get collapsed.
Right.
Because when at the time the company is now becoming successful, that is where power wrangling starts. And so when it gets there, then you want to now create your beneficiary and all that. It becomes you now have to go and speak with the partner of your business to engage with him, especially where the interests are not clearly demarcated. To agree with him, what interest do you have for you to be able to create it in your will. And so it's always necessary that when you are creating a business or you are starting a business, especially the SMEs and the sole proprietorship business in particular, always you need to ensure that before you even get to a successful land of your business, right at the beginning, you have in mind creating a beneficiary. Right. So that in case anything happens, at least that person will be able to get access to the company and manage it for you.
And you said you can change it at any time, right?
Oh yes, you can
Okay.
change your beneficiary at any time. That's why it's not made compulsory. It's not made fixed. You
Oh,
can change
okay.
it at, and it's just like how when you create a will, a personal will, you can always change your will at any time through making a new will or canceling a part of your previous will and then replacing it with another terms. You
Oh,
can
that
always
is
change
possible to.
who is to. You can always cancel it and then get someone to replace you.
Oh, okay. I see.
Yes.
But I want to know. So if you finish writing the will and you submit it to the court, then that means that anytime you want to change something in there, you have to go back to the court. Or when you finish writing it, you keep it till you are fully ready, and then you submit it. How does it work?
So normally when you create a will, you as part of the process last week we said that you have to ensure that you deposit the will at the
Or the
courts.
court, yeah.
Yeah. So as part of deposit, it has to be done instantly. The risk that comes is that if you don't deposit your will at the courts and you pass away, sometimes you create the will, you want to hide it under your bed for a while.
Yeah.
Yeah, people do that a lot, and at the end of it, by the time you pass away, you now have to take it to court, and that is where issues will come, because at that time people will start now searching in your things. The people who are not supposed to see their will, because when you create a will, nobody is supposed to see it until the time come. That is why the witnesses are not even allowed to know what is in that document.
Okay.
So if you create it and then now dispute comes up after your demise and now it has to be taken to court, problems will come up. And that's why we have elongated disputes in court, because someone may take and cut something from it, and maybe other people who actually have, someone may also have a copy of it. So it's always necessary, right, to create the will, you need to deposit at the court. And the danger that comes with the law is that if you don't deposit the will at the court for it to be sealed, and you go ahead to implement it after the demise of the person, you'll be liable.
Oh, I see.
The court will try.
So if
Yes,
if
you can't
Ebusia
implement it.
if Ebusia paying head of the family takes it and says, okay, the will is here, let's share the things, the Ebusia will be held
Yes,
liable.
you will be liable. You can't do that.
Even if
It has
nothing,
to go to the
even if
court.
there are no disputes at the end of the day.
Exactly, because you need the executors to prove the thing or go to the court to get a confirmation
Oh,
for it
okay.
to be
But
to be released.
what if the executors were also involved without the say without court or anything? They were just involved in sharing the things without having to go through all the processes.
Yeah, yes, you can. Indeed, you may say that can happen where everybody will be fine and you
Yeah.
can go ahead of it, but you never know when one day, because there is a bar until at the lapse of time where someone can bring an action before the court to challenge a will. Even if after 5 years someone can bring an action. So
Okay.
you always have to make sure that even if you are an executors and you think the family has no dispute, that's a good advice to them, is that they need to always make sure that at least it passes through the court for the due process that requires to be made for it to be made.
Okay.
It just saves the whole family and the executors from any problem in the future.
Oh, okay. I see.
Because at the beginning, maybe the person was so good, the person has distributed everything fine, everybody is fine. Oh, they are grieving at the time, so their mind will not come on it. And you go ahead and say everybody has agreed, so let's distribute the properties without the authorization of the court, and then something comes up, and you never even know. Sometimes one benefit is that, as I said earlier on, sometimes the properties the person creates in the will, it may be a co-ownership property. The person may be put in a land at Adenta Fafraha. Maybe that particular land, he has a co-ownership in it with someone else.
Right.
Or maybe the interest he has in the land. So basically, co-ownership is, let me break it down. The co-ownership is where I bought the land with, let's say, my friend Najee Koni. And buying the land, what happened was that I got the land together with her. And the consequence is that either we have it as joint ownership or joint tenancy in that land, or we have, it is one land, but I have different interests in the land. If it is joint tenancy, it means that when I pass away, everything goes into her name. So my family gets nothing.
Okay.
My family get nothing, zero. But if it is common tenancy or tenancy in common, I have my share, even though it's one land, but I have my share in it. She also have her share. So in that case, if I pass away, that part of my share goes to my family.
Okay.
So that is what co-ownership. So these are the two types of co-ownership. But our law in Ghana says that we don't do the joint tenancy. We do the tenancy in common, meaning that if I even get the land with her, part of the land goes to my family if I pass away or something like that, and then she also gets her part. So it doesn't mix. But the law does not prevent people from creating joint tenancy where if I buy the land, I'm buying it together with her. So
Okay.
if I pass away, everything goes to her. Now, you may not know, you may think you are an executor, a beneficiary, a family head. So you may not know that this particular land or property the person has, whether it is co-ownership, joint tenancy, or it is tenancy in common, you may not know. So the best thing is that you go to court for all these things to be cleared. Because if it's joint tenancy, imagine I created joint tenancy with her and I've put it in my will. Najili will come to court and challenge you one day that this property you are building on it is a joint tenancy property.
Right.
So once your father is no longer there, everything comes to me. And so it is something necessary that it has to go to court for some of these things to be ironed out, and for no dispute to be around the properties of the person. And so that is fundamental. And apart from that example I also created, there can be another example where the person has interest in that asset, the deceased has interest in that asset. And this asset the person has in it, it is even that property has been used for mortgage. But you may not know that it is under a mortgage. A mortgage is where you go for loan and then you use your assets to secure that loan. So you may not know that the will that the person has made, he's used that land for a mortgage, or that particular land has a restriction on it through the company he works with, or even that property doesn't belong to you. Maybe you see him driving a car every day, but you never know that that particular car is a company's car. So you go around distributing the properties without going through the due process in court, and later on the company will come to realize that this particular car, or the one who has a mortgage on that property, will come to realize that this particular property has been given to maybe Akwesi. And that is where the dispute will start coming up. So you always have to be very, 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 very careful and make sure that at least we take it to court. Even if you go to the court and then at the end the court prove it for you to now go and distribute, and later on a dispute comes up, it becomes easier for you to deal with it because the court gave you the authorization.
I see. Well, exactly 9:30. This is a business breakfast on Z101.9 FM with me, Nichebi Hammond. And this morning we're talking about will, how to protect your legacy through a will. And we're speaking extensively about that already. Now we were on business and succession planning. And my guest this morning is Daniel Nkrumah. He's a practicing lawyer, and he's also the founder and head tutor of Optimus Special Tuition Hub. And he's helping us have this conversation this morning. Please, I'd love to hear from you. If you kindly send me a WhatsApp, if you can, 0544321019. 0544321019. Send us your questions and your comments, and we'll read them for you. You can as well call us on 03039566641. 03039566641, and then I give you the opportunity to share your thoughts with us this morning. We're streaming live on Facebook at ZFMGH and also on YouTube at Z Multimedia. You can visit these platforms and drop a comment, and I'll read them for you. All right, Daniel, let's continue the conversation. Are you with me?
Yes, and yes.
You want to say something? Go ahead.
One thing I need to also add is that sometimes with the same reason why it has to go to court and why it has to be proved and why we need to also ensure that we get someone who is an expert to help us draft the will, is that sometimes you may have the property, especially those who have businesses. You know, some businesses transcend jurisdiction. It goes beyond Ghana. So you may have an asset in US, and then you have an asset in UK, you have an asset in Ghana. And then you put that business, because it's one business, you put it in your name for your beneficiaries to get it after your demise. But the key thing is that laws have given us that where there are properties situated in different countries, there are different laws that apply to those properties.
Oh, I see.
So if you may, it is your property, yes, but the laws tells us how that property can be given out to someone else, depending on the country that property is situated.
No, you have to explain this further.
So mostly we have a law called domicile. Domicile and nationality is different. Domicile is where you've decided, you've selected to reside permanently. It doesn't mean that is your nationality. Your nationality is where you are from, your country that you are from. So you can be a national of Ghana, but you may be a domicile of UK because that's where you've selected to reside permanently.
Right.
Yes. So you create a property, and in Ghana, our laws is that wills are governed by domicile. So when you even change your domicile, it doesn't affect the validity of your will. Meaning that when you create a will, the place that is your permanent residency, the laws in that and governing that country is what governs your will. That's what our law says. But in some countries, it is not like that. They have forced distribution. They will, especially in the Asian countries. So if you have a property there, you their laws is not governed by domicile. So your property, though you're a Ghanaian, that needs to be governed by domicile, where that is where your place of your residency. Because your property is situated in another country that does not follow the domicile approach, but they use a different law to govern properties, that your property would be affected in how they want to distribute it. Meanwhile, you've kept it in your will that it should go to someone because your place of residency tells you that you can give it to anybody.
But
you need to be very, very careful with that. And especially when it comes to land properties is governed by the place the land is situated. So if you have a company building in UK, you don't use Ghanaian laws to determine the rights and liabilities and interests of that property in UK. You use the laws in UK. So if UK law is telling you how to go about estate succession in that country, and you have a landed property there, you certainly need to ensure that your will goes in accordance with that particular law. So all these nitty-gritties comes in. That's why it's very, very important that when we are creating the will, we put that before the court and ensure that it goes through that audit. And sometimes it even comes with tax compliance. In some countries, they have taxes on estates.
That's true.
Ghana, we don't have that. So you have your property in US, in UK, and then and then when where they are taxed, their estate taxes are in application, you think that if this is your property, so you are entitled to put it in your will. You've kept it in your will. The executors goes to take it and then now ready to give it to the one you said he should benefit from it. So I have my property in UK. I pass away. I say that it should go to Nigeria. The key thing that comes in is that I said this property should go to Nigeria, but have I considered you as the executor? Have you considered the tax implication in UK governing estates? You may not, and you go for it, give it to Nigeria, and then later on it will rise up that you didn't pay the taxes on it. And this will start happening. So we need to always ensure that we get the right experts to get us drafting the will, so that all these nitty-gritties coming up would be settled.
Right, I see. So there are lots of things. I'm curious as to what differences. I mean, how much of a difference would there be in the laws of these countries? So, for instance, somewhere in the UK and then Ghana, how much of a difference would there be in there that the laws that will apply here will not be relatively similar to what is there? I don't know if you get a question.
Yes, I get it. So yes, in I must say that in most Commonwealth countries, because we are colonized by one master, most of our laws are similar. But some countries have gone ahead to change the previous law. So the laws that govern most Commonwealth countries is what we call the common law. The common law is a law that, in simple terms, during the time laws were developing, systems were developing in Britain, it was said that where judges make a decision in a particular case, they pass the decision on to the next case if they meet a case that have similar facts.
Okay.
The rule that they develop applies to that case. So imagine that I have a property, and then the property is situated in Ghana, and then I have a case for the first time, and the court says that this property is situated in Ghana. The laws in Ghana should govern it. If subsequently another case comes up and it relates to a property that is situated in, let's say, Nigeria, the court will say that, oh, there was a previous case that the court held that where the property is situated, that should be where the laws of that place should govern that property. So then let's apply the same law to this, because it's the same scenario. So that's how common law came about.
Okay.
So in most countries that are governed by that were colonized by the Britain, we work under the common law. But our laws, especially when it comes to Ghana, for instance, our laws permit Parliament to change the common law. So we've changed a lot of positions in common law when it comes to contracts, when it comes to company and all that. We've changed a lot of positions in common law.
Right.
So once the country changes the common law position, we are no longer on the same length.
Okay.
So our laws will be different. And it's one example I've given is that in common law, they not impose estate duties or taxes on estate. But UK has that. Ghana, we don't have that. So where you don't know some of these nitty-gritties, you may think that the law, because it's common law, we are the same.
We are the same.
But there will be some changes that the country has made.
Okay.
And that will mean that you need to be very careful with it. And also sometimes, sometimes, apart from the common law, where the country is a civil law country are those countries that were colonized by France, Portugal, Spain, and the likes.
Yeah.
Those countries are civil law countries. So they have a different system.
Okay.
They have a different system. So if your country like Ghana don't have a relationship with them, if I say relationship, a legal relationship where we've entered into pertaining to, let's say, Wales, their laws will not sync with how our laws will be. So you need to ensure that you go in line with the laws. So there'll be differences between that. And it's one thing that when it even comes to taxes and international agreement, most countries, because of these disparities, where they see that where a country sees that most of their members are having properties there or they are residing in that country, the government needs to always go into entering a bilateral arrangement with the country to ensure that there is some form of uniformity in our laws, how we work and how we go about certain things. So we have double taxation arrangement with certain countries. Said that even when we charge you, when you have a property in, let's say, Canada, and Canada charges you taxes on that property, and you come to Ghana, we won't charge you taxes again. Or even if we will charge you, it will be reduced. It won't be that we will charge you separately than what the Canadian government has charged you because of the bilateral arrangement that we have.
Okay.
So in the absence of bilateral arrangement between Ghana and maybe a country, like in the civil law country, for instance, that has a completely different system as to how Wales needs to be operated, then you will be subjected, if your property is in that country, you will be subjected to the laws of that country.
Right. I see. So what steps should an entrepreneur take to ensure smooth business succession?
Yeah, so critical is that every business, at least when you are creating a business, you mostly get, now it's not common, but the appropriate thing or the right thing to always do is that before you create a business, you need to at least get a lawyer to help you assess the business that you are creating or you are establishing and then the laws that governs it. Because you may, for instance, someone may be coming to Ghana to open, let's see, an export import business in Ghana. But you coming to Ghana, we have laws in Ghana that tells us that if you're a foreigner and you are coming to operate a business in Ghana, you don't just register with the companies, register of companies. You need to also register with GIPC. So if you don't get a lawyer who will guide you as to these things, you will end up creating the business, and then you will know some of these laws govern it. So that is where problems now start coming, where you go ahead, put your property in a contract or in a will for someone to get it, but because you didn't do the foundational work well and you didn't have a lawyer guiding you, even after you establish the business, you don't have a legal department with your business or having a lawyer who would always help you, your property will now end up becoming a dispute, or your business will end up collapsing because of some of these things. So it's key that entrepreneurs always need to ensure that, yes, you do your business parts, but ensure that whilst you do that, if you have any idea about distributing of your properties or creating a property in a certain jurisdiction, be it even in Ghana or outside the country, at least make sure that you get a lawyer to help you understand the pros and cons around that, so that no matter whatever, death is inevitable. So even if you don't want to plan a will, which we recommend everybody should do, death is inevitable. You will go and your family need to now take care of that property. So having a lawyer to guide you and then advise you on the properties that you are having, the business that you are having, and the relationship that you have with certain people in your businesses would always help you to ensure that you arrange your affairs internally well. Because lawyers work with confidential arrangements. So he would ensure that you get that done well. So even when you pass away, your affairs is much more arranged. Even if it's not a will, companies can sign an arrangement or have an arrangement internally that automatically tells who takes what property and who handles what, without necessarily putting it in a will.
Okay.
So you can easily do that through a lawyer coming in to help you. And also, when you're entering into a partnership with people, always make sure that the one crucial thing you ask yourself is, what happens to the property or the interest I am acquiring in that property should I pass away? Because we are talking about wills. So what happens to it? For you to determine that, you need to ask yourself whether the interest is even clear for you. Is it very much clear to you? If it is, then that is where you need to now decide. And also, when you go for landed properties, land properties have interest in it. So when people buy land, they always think that, oh, I'm the full ownership. I have the full ownership of the land. Not all lands you have full ownership. Sometimes what you bought was a lease.
Yeah.
So it means that you are not your tenure will end at a certain time.
Yeah.
So the ultimate owner is there. And even those who are not even holding leases, they may be holding customary tenancy arrangements. So you ask yourself, this interest I have that I'm building my office on it, or I'm establishing my container on that land, or I'm establishing a certain business on that land. It is a lease. Should there be any instance that happens after me, what happens to that lease? You need to have a lawyer to help you so that arrangement will be made for you in your business without necessarily even creating a will. If you don't want to do a will, the arrangement can be made in that lease arrangement, in your business arrangement, to ensure that even in your demise, issues doesn't come. Because we had issues where people pass away, and there is a dispute between on that property, that landed property, just because some people think the interest that you got from the owner of the business is not right. You didn't get it from the right source and all those kind of things. And that affects the succession of your company.
I see. So there are so many nuances in there. And I'm going to come to the part about getting a lawyer very soon. But let's talk about the family dynamics. Now, what considerations should someone make what considerations should they take if they have blended families, they have some dependents and also some vulnerable beneficiaries.
Blended, if you say blended, could you clarify that part?
Yeah, so maybe they have more than, I mean, maybe more than a wife, So I don't know if you get it. So more than one wife.
And you want to create a will for the family.
Yeah.
Okay. So yes, first of all, if you are going under the Wills Act, of course, you need to make sure that you cater for all your family members. As I said, direct family members include your wife, your husband, and your children. So even if you have 3 wives, they are direct family members.
Okay.
You need to make sure that you cater for all. If you don't, our laws tells us, and our Supreme Court have held recently that if you don't do that, if you don't create a benefit for those people in your properties, the court is giving the room to make reasonable provisions for them. So you can choose that, this is my favorite wife. Maybe I get married. Normally when I'm teaching, I do examples so your listeners will permit me with the examples I'm creating a lot. So let's say I create a will. I'm married, and then when I created the will, I gave Akusia the biggest portion of the estate because she is my favorite wife. And then I gave Ajwa the least. And I decided not to give Abena nothing at all for Abena. Abena can take this will to court and so that she's my wife. And so she's entitled to something. As a result, the court will step in and make reasonable provision from the will I've already distributed to people. And realign to ensure that Abena will get some benefits. So you must always ensure that if you are creating a will in your you need to critically ensure that you are making reasonable provision, and the word is reasonable provision for your spouses and then your children.
So in instances, I mean, still on blended families, in instances where you have adopted children, or maybe a child you brought from a previous relationship, what happens?
Yeah, it is very much important. If you read our Constitution, Article 28 tells us that we don't even want to discriminate between types of children. We say the law makes it known that your children should get benefits from your estate, whether they were born wedlock or not. So you can't say, these children, this child of mine, I gave birth with her before the marriage, and so my properties I have, he doesn't, he or she does not deserve reasonable provision from it. But the one that I gave birth with my real wife, my wife would rather want me to give him or her something better. No, Article 28 would block you from doing that, because you need to provide and ensure that that child gets benefit, even though he was born wedlock. And Section 13 of the Wills Act also gives the courts the room that they should come in to provide reasonable provision for a child, especially when that child is a minor. The court will come in if there is no reasonable provision for that one. But fundamentally, when you are creating your will, you need to ensure that your children are clearly defined in the law. In your will. If you say children, are you talking about dependency? Because we have children that are dependents.
Yeah.
And we have the biological one. So which of them? Clarify. Don't just use the word children, and then because we have cases where even the courts have interpreted nephews to be children of you. So you need, because the type of relationship and the type of care you provide for the person comes in. So if you say children, into the mind of the judge, it includes that person, that child you've taken care of all the time. Imagine you marry and then you adopt, or you go for whether adoption, or you go and pick up a child from one of your family members, and the child live with you from 1 year old all the way to the time that the child became 16 years old. You've taken care of the child, taking the child to school, you've provided practically everything for the child, and you are creating your will, and then you use the word children. you have that child plus your biological children. If you have the word children in your will, all your properties go to the children, and it goes to court. Your biological children will come and see that person is not your child.
Yeah.
Because he is not your biological child, of course. But the court, in reading the will look at your intention, and your intention is deduced from the will and how things happened.
Okay.
So you've taken care of this child from day one. If you don't want to provide something reasonable for your child, why would you go for a child, take care of the child, go to school and all that, and then when you are passing away, you are making your will, you are not providing something. The court will not read that into the will in that way. So the court would import reasonably in it that if you say children, because you didn't clarify that they are biological children or it include adopted children, that particular person you went to take from your family member or someone else to come and stay with you is part of the children for this context. So she is supposed to also get the benefits.
Okay.
So if you are creating your will and you don't want that to happen, the best thing to do is to clarify. If you say children, what do you mean by children in your will?
So you don't leave room for any ambiguity. I see.
Exactly.
All right. Okay. So let's. Our time is almost up, and so we'll try and touch on a few other things, and then we can go. Now, many people try to create their will. I mean, their own will, or maybe they use some online templates and all of that. What are the risks of doing it yourself?
Yes, it's very necessary because now AI has taught us a lot. That you can even create a lot of legal documents online. Yeah, you can do that, of course. But our laws in Ghana has not gotten to that level where we have digital wills. Digital wills. Yes, in some countries they've advanced that much to that level. But for us, we are yet to get there. So even our laws provide that even if you create your will digitally, you need to still have it printed for it to be on a paper for people to sign. So it is very much important that is how our law requires that it should be in paper, handwriting, so that people will be able to sign. So even if you choose to create it online, you can. But when it comes to the point of enforcement, that is where you have a struggle. Because our law has not provided that you can create. It's just like last week where someone asked about video, creating a will via video. It's the same thing. The digital wills is yet to be introduced in our country, and so you will struggle to do that.
So yes. Anyway, what red flags should someone watch out for? When they are choosing, not necessarily creating the will, when choosing somebody, a lawyer, because you've been talking about the fact that you need a lawyer to help you do it. What red flags should you look out for when you are choosing a legal counsel for planning your will or estate planning?
I must say this is very difficult to actually determine, but I think that the key indicators I can just give for our listeners is that when you want a lawyer to come in to help you, at least try to engage the lawyer on a consultation base and tell the lawyer the actual thing you want to do, so that you see how best the lawyer would interact with you. That will give you a clue as to whether you can get the lawyer can help you in the first place. Second is that always make sure that you ask for terms of engagement or letter of engagement from the lawyer, because the letter of engagement, which specifies the scope of what the lawyer will do for you. And that's all. It's not just that the lawyer will say, I'm going to write the will for you. But the letter of engagement helps you to know how best would the lawyer help you. And that will also tell you if there is any advice that the lawyer will also give you, or some other process that the lawyer will take. For instance, if there are landed properties, the terms of engagement or the letter of engagement will tell you what the lawyer will do before even adding that property to your will. So those things tells you that, okay, the lawyer is actually giving you a detailed of what he's going to do. And also, don't just go for a blanket fee quote. Fee quote is where the lawyer tells you, I'll charge you maybe 2,000 cedis to do your will for you. You ask what goes into it.
Okay.
Because then maybe what the amount the lawyer is telling you, you may say it is too high. But in actual fact, if you ask the lawyer, what is the breakdown of it, which always is tied to the time of the lawyer and then the scope of work of the lawyer. It will give you a clue as to what you want to do, and that can give you an informed decision whether you want to even carry on or you want to remove something from what the lawyer wants to do. Because you have the right to say, oh lawyer, this is what you say you do. Okay, can you change this for me, or can you just drop this one? I think this one I won't add it.
Okay.
So once you get those clues, it helps you to easily navigate, and always look for lawyers that also have some form of knowledge or skills in the field you want to create the will. Because as I've given you an example, imagine the will is transcending Ghana. The properties you want to create a will for is going beyond the shores of Ghana.
Yeah.
You certainly need to also ensure that the lawyer understands the laws beyond the country, so that the lawyer need not know the nitty-gritty of the laws of the country, no, because that is not how I mean. We have laws called conflict of laws or private international laws, and there are international agreement that governs these type of transcending country boundaries. So you need to appreciate that property, at least the lawyer it has an idea about that property and the laws that can govern that property and that your interest in that country. So that all those things will go into it to help you get a very good will. Otherwise, you would end up having the will and you will not be able to enforce it properly after your demise. And one other thing is that now people are creating businesses with the business world. People are creating a lot of businesses online.
Yeah, that's true.
They are going e-commerce and all that. So there are people who are selling wigs, they are selling bundles, they are selling footwears, they are selling all that online. And you ask them, please, I want to buy your spray. They will tell you, oh, I don't have a shop, so I'll deliver it to you. Now, the key concern is that if you want to create a will on those things, you need to make sure that you get someone who would assist you to appreciate the e-commerce space. Because lawyers people think the work of lawyers are only just to go to court and argue. No, we have types of lawyers. Lawyers covers almost every aspect of our life.
I see.
So you need to ensure that your e-commerce work that you are doing, which is the digital world, you ensure that the lawyer understands that space, and or even have you incorporating the accurate information you need in your will, so that it doesn't affect that situation. And fundamentally, our listeners, when they have passcodes, pass keys to their mobile money, their bank accounts, their YouTube channels, their TikTok channels that they monetize, and other digital platforms that they are assets, to avoid what happened in Canada to a very rich company where they lost over $190 million because of passkey that they were not able to find. Do your best possible to save your passkey somewhere, so that even if you create a will or where you don't create a will and you pass away, at least those your digital assets can also be something that can go to the rightful owner. And if you're afraid that maybe, hey, how do I write my Muhammadi PIN code? Then someone will come into the easy way you can do is that when you're creating your will and want to add those digital assets to your will, you create a clause in your will where you give it a unique coding, so that once someone accesses that unique coding, it goes through all, it can access almost everything inside the coding that will lead to the accessibility of the other digital asset that you have. You can do that, so that it helps you save your businesses from that situation where in Canada, some a family lost or a business lost over $190 million just because of passkey.
Right.
Yes, and as I've said, 20% of companies almost every year is assessed that they lose. Those who do digital businesses, 20% always is assessed that they get to lose those businesses because of unplanned or improper planning for estate succession.
Okay. Right. Okay, Daniel, maybe my last question to you. For our listeners who are convinced today that they need a will, what are the first 3 steps they should take immediately before we go?
Yes, so the first things first. So before that, let me say that we've written comprehensively on digital assets and will, and I will share with you after the program later in the day, so that you can also let your listeners see it on your various platforms, because it will help them, digital assets and wills, how they go about it. But crucially, when you are a listener and you've not created a will, the first thing always I tell everybody is that you don't need to be rich to have a will. You need to start thinking about wills. In fact, people even believe in lifespan, that every country has a lifespan. So we need to know our lifespan, and we have that in mind, that at least I need to have plan around it. People say life begins at 40. But I must say, don't wait for 40 years before you say, oh, my life has begun. So let me create a will. No. Once you start getting properties, start thinking about who is to get what. And also, when you are opening a bank account, please, the aspects in the document we fill that asks for next of kin, take it seriously. People will fill a form. It can be an insurance, it can be a bank account, it can be something, and they're asking them less of kin, and they are just reluctant about it. Put some form of thinking in it, and make sure the person that you are choosing is actually someone, if you are creating the will, you think you will give that person access to that. Because it's more or less like a will that you are doing. It has that effect. So always make sure that you pay attention to these key things. And of course, just write them down. You don't necessarily need to engage a lawyer formally at all points in time to even discuss with the lawyer about your assets. Sometimes you can just engage with a lawyer friend and ask, oh, Charlie, I have this business here. So what do I do? If I want to really give it out, is there any law that I need to? Sometimes your lawyer friend can just give you an advice that's for free. So that you take that advice quickly and just help you prepare something ahead. So fundamentally, these are some of the key things that we need to do. And then the business world, those SMEs and sole proprietorship especially, when you are creating a business, always have in mind to have a special arrangement for your succession. Because businesses collapse a lot in this country, where they are created to be a family business, one man business, family-like business that does not have a clear path of succession. So always make sure that when you are creating a business, even if you don't do it as a will, create a succession in your business, so that after your demise, something can be clear for all of us to use it to govern how that business needs to progress.
Right. Okay. Daniel, thank you so much for your time. Really, really grateful that you joined me this morning to share these insights. I think this is something that everybody must know. Thank you so much.
I'm grateful for your time, and I hope the listeners would enjoy it. And one last thing, let me say before I go, with just 30 seconds.
Please go ahead.
It's for people who are running state real estate, like hostels, landlords, and all that. Please, most of these people actually don't also have wills. Most of these. So I am fortunate I manage a hostel, which is just in Court Hostel. Now, one thing is that I make sure that, because I'm a lawyer and I'm in that field, and understand the danger that comes with not having a will with respect to properties that you are managing, I've ensured that this hostel, at least the owners will create a will around it. Not necessarily putting it in a written document as a will, but what I mean by a will in this case, I'm saying that way for everybody to understand, that you have a succession plan where if this thing happens, the company has a clear, or the hostel or the business has a clear path as to who steps in to manage it for you. So I want to encourage all people who manages a hostel, who manages a hotel, those who are also involved in the landlord-tenant relationship. If you have him in the chamber and hall, please ensure that you quickly include those things. Have a succession plan in your internal arrangement, where you clearly know. Otherwise, you will pass away, especially the landlords. You will pass away, and then your children are fighting over who goes to take the proceeds.
That's true.
Of that property from the tenants, and it becomes a lot of problem for you when you can actually have a good arrangement done before you pass away, so that everybody understand that, oh, when you are going, daddy says that this tenancy money comes to so and so person. It has happened in a lot of cases. So let's try to prevent that if you are in that space as well, and not only those who are selling and those who are doing digital business that need these succession arrangements, but those who are engaged in the real estate also needs it. So that's the addition I want to make for people to get it.
Okay, Daniel, thank you so much for your time, and thanks so much for sharing.
I'm grateful. And do have a wonderful day with
All
us.
right, you too. All right, that was Daniel Nkrumah. He's a practicing lawyer. He's also the founder and head tutor of Optimus Special Tuition Hub. He was my guest today on the roundtable, and he shared so much with us in terms of planning your estate, essentially planning or drafting a will, really. We've spoken extensively, so I wouldn't know. I want you to visit our social media platforms and go and play back. It's a very important information that you need to know. It says that planning a will, you don't have to be wealthy to be able to do that. You can do that at any time. And it helps you, it helps your family, it saves everybody from all the back and forth. And probate takes so long. Sometimes it says it takes more than 5 years to be able to recover some of these things that you have put in place already. I mean, for your family to do that. So it's very important that you put in place a will before your passing. Have a succession plan. If you're a business owner, if you're an entrepreneur listening to us this morning, have a succession plan so that when you are no more, your families don't fight and all of that. All right, so that's how we wrap up today. We're back again tomorrow for the Friday edition of the Business Breakfast on Z.